So let's get started. Well, thank you everyone for joining us. We are gathered here in cyberspace today to celebrate the publication of Erwin Chemerinsky's new book, Presumed Guilty: How the Supreme Court Empowered the Police and Subverted Civil Rights. We're absolutely delighted to have Erwin beaming in from Berkeley here today. He'll be joined in conversation by Professor Laurie Levenson from the Loyola School of Law. And we're also really lucky to have Bert Deixler, one of the co-owners of Chevalier's books, here tonight to offer introductions. So before we get started, just a few little housekeeping details. The event will start with introductions from Bert, then we'll have Laurie and Erwin jump into conversation for about 40 minutes or so, and then we'll open it up to questions at the end of the meeting at about 6:45. If you have a question along the way or something pops in your head, you can type it into the chat box down below on the call, and when we get there, I will relay it to Erwin and Laurie. And lastly, but not least, if you haven't already gotten your copy of Presumed Guilty, you can do so at the link that I'm just about to provide in the chat at bookshop.com. And you can also stop by to Chevalier's in person if you're in Los Angeles, grab a copy. We've got boatloads. And even if you're not in LA, we ship nationwide, so you can give us a call. So without further ado, I'm going to hand things over to Bert and he'll get us launched. Thanks so much for joining us, everyone.
Thanks, Miles. And thank you all for being here. This is a special evening for me. You know, in the celebrity-driven world in which we now live, there are some special celebrities known only by their first names. I think of LeBron and Giannis, Fernando and Sandy, Bruce and Madonna, maybe Liberace. But we have with us today the equivalent of legal superstars who are really known only by their first names. There's no reason to say anything more than we have Laurie and Erwin with us today. But as long as I have the floor, I'd like to just say a little bit more. Laurie, who's the interlocutor this evening, is a great friend, of course, of Erwin's, frankly, a great friend of me and my family. She's a distinguished professor at Loyola Law School. Among her accomplishments, aside from having been being a former federal prosecutor, is this project for the innocent, which she has been running to great effect. And the type life that she has lived has caused all of us who are in the legal world to admire her and feel as though we're letting everybody down by doing what we do. And I always like to say of Laurie, if you like camels, you want to be near her house on any a major Jewish holiday. We're lucky to have Laurie here tonight. Dean Chemerinsky, of course, is probably the leading American constitutional scholar of his generation. He is a leading advocate before the court. He's a brilliant academic, and he is among the most prolific public intellectuals in the United States today. I like to always tell the story about having had the chance to be the managing partner of a national law firm, and the only luncheon that people would kill to get tickets to was the annual Federal Bar Association luncheon, in which Professor Chemerinsky would discuss the forthcoming Supreme Court term. And I was quite sure people weren't there for the chicken. Let me speak just 30 seconds about this really wonderful, important, must-read book. It really examines the devolution of American constitutional law set in the criminal procedure world. It talks so explicitly about what has happened with the passage of time, really pointing out the anomaly of the Warren Court. What makes the book so special for me is the clarity of writing. This is not a book you need to be a lawyer to enjoy and understand. And what it really does bring home further for me is the fact that all of these important constitutional cases involve human beings having some interplay with police, the courts, and the system of justice, and how that leads to these principles and laws that we think are so valuable. It really does call out the question of race and judging and a system that is dysfunctional. And happily, at the end of the book, and I encourage you to get to the end, the best part of all of it is not just the criticisms, critiques, and history, but rather a multi-point plan for improving the system so that the system of justice turns out to be just. So rather than hear myself talk any longer, I'm going to turn it over to Laurie and Erwin, and thank you so much for being here tonight. It really is wonderful.
And thank you, Bert, and everyone. It's truly an honor and a pleasure to be here. And I see so many of my friends who have tuned in. And of course, the person we admire so much, Professor Dean Erwin Chemerinsky. So let me cut to the chase here. We're talking about this book, and you should all buy it. And you should buy it from Chevalier's because it's a fantastic book. You know, I'm making all my students do it because they'll learn from this. And tonight, I hope we'll learn from Erwin as well. You might have seen the New York Times or has already done a review, very favorable, not surprisingly, of the book. They talk about him and why it's so special because, quote, he writes well, he's an experienced advocate, he's been before the court on many occasions, he's a consultant to police forces and his own experience as well. And they boil it down to this, quote, in fact, all concerned citizens, that looks like you, need to read this book. And I want to talk to you, Erwin, by starting out and asking, why did you write this book now? Because you've been dealing with challenges in the criminal justice system and law enforcement for decades. Why now? And why make it a criticism, a focus on the Supreme Court?
Thank you. Let me start by thanking Bert for the kind words and Chevalier's for inviting me to do this. I wish we could be in person, but I'm so glad we could do it at least by Zoom. And I want to thank Laurie. Laurie read a draft of the book and gave me wonderful comments and suggestions. And it would be much better if I even followed more of her advice. In answer to your question, why write the book now? I, like you, have been teaching criminal procedure for many years. I use a case book that Laurie and an unnamed co-author write. And after teaching it in the fall of 2019, I was so frustrated when I put together the various doctrines of when can the police search people and arrest people? When can the police question people? When can the police do identification procedures? To see how little control there is on the police, that the provisions of the Constitution that should be limiting police behavior aren't. And the result is race-based policing in the United States. Also, even when there are rights, the Supreme Court has gutted the remedies. And I'm not sure, Laurie, I can answer the question, why at that moment in December of 2019, having just taught the course, was I especially frustrated? But maybe it's the years of teaching the course and seeing these cases and having instructed about these cases, it just added up. And I signed the contract to write this book in January of December 2018. So I signed the contract in January of 2019 to write the book. And then when the events of George Floyd happened, the tragic death in Minnesota, the editor, Bob Weil at Norton, said to me, how soon can I get the book? And I finished the book in the summer of 2020 in the wake of the death of George Floyd, which made all of the things that I wanted to say seem so much more salient.
Erwin, part of the greatness, and there's so many aspects of this book that I love, is telling a bit of the history of the police and the Supreme Court's relationship with the police. I think many people mistakenly think that there's always been rulings regarding police behavior, but as you point out, we haven't always had the same type of police forces or rulings that we have today. Can you share a little bit about that?
Of course, one of the things that I wanted to do in this book was look historically at the relationship between the Supreme Court and the police. It might be a surprise, even to some of the lawyers on the call, that there were virtually no Supreme Court cases from the founding of the Constitution, the adoption of the Bill of Rights in 1791, into the late 19th century, dealing with things like searches and arrests or police interrogation. And even in the first part of the 20th century, the Supreme Court put very little in the way of controls on the police. And if the Constitution and the court isn't limiting the police, who will do so? So often the political process is unwilling to check the police. And so I wanted to tell this history, starting with the founding, talking about how police forces developed and continuing to today.
And in doing so, you talk a bit about slave patrols. I think people might not have known about those and sort of the racist origins of many of our police departments.
There weren't organized police forces as we know them today at the time the Constitution was written. Of course, there were some performing policing functions. There'd be the local sheriff, often the constable, maybe the marshal, but there wasn't a police force. The idea of having a group of people charged with detecting, preventing, solving crimes didn't exist then. The first real organized forces of what we would think like police forces were slave patrols. These were groups of people who were organized to apprehend runaway slaves. They were very much to protect the institution of slavery. The organized police forces of the sort that we know today didn't happen until after the Civil War in the United States.
Erwin, what difference did the Warren era make?
The Warren era, and here I'm really talking just about the 1960s, are the only time in American history we had a court that tried very much to control the police, to use the constitutional provisions about policing to impose limits. Let me give some examples, and they're familiar ones to everyone. In 1966, in Miranda versus Arizona, the Supreme Court said that police interrogation in the station house is inherently coercive. And to protect people from the coercion, police have to give warnings to those who are questioned in custody. Police have to tell the person, and we all know these, that it's right to remain silent. Anything said could be used against the person, right to a lawyer. Person can't afford one, the government will provide one. That was a Warren Court decision. In 1963, in Gideon versus Wainwright, another case that's familiar to people, the Supreme Court held that if a person is being tried in state court where there's a possible punishment of prison sentence, the state has to provide a lawyer. Isn't it amazing that until 1963, a state could try a person for a serious crime, person could be convicted and sentenced even to life in prison without needing to provide a lawyer. In 1961, in Mapp versus Ohio, the Supreme Court for the first time said, if local state police officers engage in an illegal search, the fruits of the search have to be excluded. All of these came from the Warren Court, and I give many examples as well.
Well, Erwin, it seems like since the Warren Court, there's been a pushback on all of those things. And I'm wondering why. How much does politics play a role in our basic rights regarding the police?
Politics and ideology plays an enormous role. Richard Nixon ran for president in 1968 against the Warren Court. He said he wanted law and order. He said he wanted strict constructionist justices, and it was a thinly veiled appeal on the basis of race. He was very much committed to appointing conservatives to the court, and he got to appoint 4 conservatives between 1969 and 1971. A statistic that I find particularly stunning is that between 1960 and 2020, there have been 32 years with a Republican president and 28 years with a Democratic president, almost even. In fact, in 2024, it'll be even, 32 and 32 years. But between 1960 and 2020, Republican presidents appointed 5 Supreme Court justices, Democratic presidents appointed just 8 Supreme Court justices. And I think it explains why we've had a very conservative court, and that correlates with being a very pro-law enforcement court. But Laurie, I want to add one thing to this. You asked me about what's the role of public pressure. I think it even had an effect on the Warren Court. One of the pivotal decisions, I think one of the worst decisions in this area, was in 1968, Terry versus Ohio. It involved a couple of men who were on a public sidewalk in Cleveland, and they were walking back and forth. There's a dispute over how many times they walked back and forth. It's interesting that at each higher level of the court, the number of times they walked increased. A police officer saw them and he thought they were casing the joint. I don't think it's irrelevant that the officer was white and the two men were black. The officer decided to stop them, to frisk them, and found guns. Two of the men. The men hadn't violated any law to that point. They were doing something completely illegal, walking on a public sidewalk. The Fourth Amendment, as you know better than anybody, says the police are only supposed to detain somebody like this, search somebody, if there's, quote, probable cause. But the Supreme Court in an 8-1 decision said that police don't need to meet probable cause. So long as they've got, quote, reasonable suspicion, it's enough for a stop and a frisk. This is very much increased, legitimated, racialized policing in the United States. Studies in every major city show police stop and frisk Blacks, Latinos much more often than whites. Why did the Warren Court in 1968, when it was the most liberal Supreme Court in all of American history, decide this way? Earl Warren, who wrote Brown, wrote the majority opinion. William Brennan, Thurgood Marshall, the Legal Lions, the liberal giants were in the majority. Only William Douglas dissented. I think, Laurie, this goes directly to your question. It was the political pressure of the time, the intense criticism of Warren Court decisions as handcuffing the police. It was public anxiety over crime. It was the time of riots in many major American cities. And even the Warren Court fell prey to it. And Terry versus Ohio has been the law ever since.
Erwin, let me push you a little bit. Worst case of all time from the Supreme Court, especially as it relates to issues of race. Now, you've pointed out Terry, but since then they've decided other cases, haven't they, that say we're going to be racially blind, but they know exactly what's going on.
I have many nominees for the worst Supreme Court case ever. Dred Scott versus Sanford, Plessy versus Ferguson, Korematsu versus United States. But in this area, in more modern times, I'd pick a case called Wren versus United States. And my guess is, if I asked most of the audience, have you heard of Wren versus United States? Except for people who practice in this area or teach in this area, probably not. But the bottom line of Wren is it makes it easy for the police to stop at least any motorist, if not anyone, anytime. Let me explain why it's not hyperbole. Wren involved undercover police officers in Washington, D.C. They saw a car stop what they said was an unusually long amount of time at a stop sign, about 25 to 30 seconds. Now, as Laurie knows, I have the world's worst sense of direction. I am often at a stop sign, 25 or 30 seconds. It used to be to try to read a map, which I can't do. Now it's to look at my GPS. Based just on that, the officers decided to follow the car, and they waited until the car turned without a signal. The officers then pulled over the car for the traffic violation, ordered the driver and passenger out, did a search of the area where they were sitting, and found illegal drugs. In DC, undercover police officers like these aren't supposed to enforce traffic laws. It's clear that the traffic stop was just a pretext. The police wanted to search for drugs. Again, I don't think it's coincidence that the driver and the passenger were Black. The driver and the passenger say, This violated the Fourth Amendment. It wasn't a legitimate search and seizure. The Supreme Court, in an opinion by Justice Scalia, says the motives of the police officer don't matter. So long as the officers had probable cause or even reasonable suspicion that the driver was violating a traffic law, the stop becomes legal. Doesn't matter if it's pretextual. If you follow any driver long enough, you'll see them commit a traffic violation, go a mile over the speed limit, change lanes without a turn signal, not stop long enough at the stop sign. I've seen it asserted that every driver within 15 minutes will violate some traffic law. Wren just opens the door to the police being able to stop anybody. And study after study, including those in Los Angeles, show that police are far more likely to stop Black and Latino drivers than white drivers.
You know, Erwin, in terms of the tools to change police behavior, the book talks about what some of us may know as the exclusionary rule, that police don't get to use evidence that's illegally obtained. But there's been a lot in the news about what about suing the police? And why is it so difficult to sue the police and get any proper remedy in doing so?
It's a great question. I do think it's important to distinguish between the rights that people have and the remedies that exist when the rights are violated. So far, what we've been talking about is how the Supreme Court has lessened the rights that people have. But your question now goes to, even when people have rights, the Supreme Court has said there's no remedy available. One remedy is what you point to. If the police violate somebody's rights, sue for money damages. Well, it's much more complicated than that. You can't sue the city or the police department unless you can prove the city's own policy caused the violation of rights. I know that Minneapolis settled, wisely so, with George Floyd's family, but it would have been very hard for George Floyd's family to win a lawsuit against Minneapolis because it couldn't prove that its policy caused Derek Chauvin to use the chokehold. Well, if you can't sue the city, you can try to sue the police officers. But the Supreme Court has developed the doctrine called qualified immunity that makes it very difficult to sue police officers. It's been interesting to me to see this technical legal term, qualified immunity, become part of the general vocabulary in society. To explain it just for a moment, whenever a government officer is sued for money damages, there is always what's called an immunity defense. Now, this isn't found in any federal statute. It's obviously not mentioned in the Constitution. It's invented by the Supreme Court. The Supreme Court has said some government officers have absolute immunity and can never be sued for money damages. Police officers, when they testify as witnesses, even if they lie on the stand, can't be sued for money damages, absolute immunity. Prosecutors for their prosecutorial acts, judges for their judicial acts, legislators for their legislative acts have absolute immunity. All other government officials, including police officers, when they're sued for money damages, have qualified immunity. And the Supreme Court has said that this means that the officer can be held liable only if the officer violates clearly established law that every reasonable officer knows. And over the last 2 decades, the Supreme Court has said, unless there's a case on point, exactly saying that what the police did is unconstitutional, the officer can't be sued, qualified immunity.
You know, by the way, for the audience watching, the question came in, will we take questions? We will sort of towards the end of the program. So just put those into chat and we'll keep track of them. But following up on that, Erwin, after George Floyd, after the marching in the street, you know, there's the George Floyd Act with some type of suggestion that this can change, that we can do away with qualified immunity. Is Congress going to put any changes on the court on this doctrine that has really prevented people from getting relief from police misconduct?
I'll be a law professor and answer a question with a question. Is Joe Manchin willing to change the filibuster? The George Floyd Act has passed the House of Representatives, but it's stalled in the Senate. And it appears that Senate Republicans will filibuster any attempt to have police reform. My hope is that one way or another, Congress will adopt many of the provisions in this law. Let me give you some examples, Laurie, what's in it. One of the things it would do is prohibit police from using the chokehold. It's the chokehold that killed Derek Chauvin and Eric Garner and many others. Another thing that it would do is say, basically, the police have to knock and announce before they go into a dwelling, except in the most extraordinary circumstances. When the police don't knock and announce and just enter, then it endangers the officer and the people there. That's what led to the death of Breonna Taylor. One of the things the federal law would do is change the definition of qualified immunity. Simply put, if an officer intentionally violates the Constitution, the officer would be held liable. It would require that police departments keep track of the race of individuals stopped. There are many studies that have shown just requiring the officers to record the race of those who they stop decreases racial profiling. But what I want to add, Laurie, is even if Congress doesn't do this, state legislatures can adopt laws. Local governments, police commissions can adopt laws. Many police commissions have now outlawed the chokehold for their departments. More need to do so.
Do you think the justices on the court realize and just don't care? Or why do they make these decisions that make it so difficult to hold the police accountable?
I think it's a complicated story. I think we all are a product of our environment. It creates for each of us a narrative for how we look at the world. I've often remarked, and you've heard me say it, that I can predict what the Supreme Court's going to do in Fourth Amendment cases by whether the justices could imagine whether it would happen to them. There was a Supreme Court case that you're very familiar with from not quite a decade ago that involved the police putting a GPS device on the undercarriage of a car. And at the oral argument, Chief Justice Roberts said to the lawyer for the United States, "Are you saying that the police could put a GPS device on my bumper without needing a warrant?" And Justice Kennedy followed up and said, "Are you saying that the police could slip a GPS device in my pocket?" I knew then it was all over for the United States government, and they lost unanimously. The justices have provided great protection against the police looking at cell phones, because they've all got cell phones. But I don't think the justices have a clear sense of what it is to be Black or Latino in a major city in the United States. And I think that they start with a framework where they believe we need to empower the police to control crime, rather than a framework that says we have a real problem with racialized policing. I'm just going to turn the light back on.
Oh, okay.
It's bad.
Move around here.
Okay.
I want to shift just a little bit to the idea of the focus on wrongful convictions. As Bert mentioned, near and dear to my heart, we have a tremendous squad here at the law school of really dedicated students and staff. And we have many more cases than I would have ever believed when I was a prosecutor of people who we believe were wrongfully convicted. How have Supreme Court decisions contributed to that, whether it be in the use of snitches or identification, but beyond the Fourth Amendment issues?
Let me talk about eyewitness identification. As you know, the work of the Innocence Project has shown that many wrongly convicted individuals, and this is after they're exonerated, say through DNA evidence, were convicted as a result of false eyewitness identifications. Eyewitness identifications are very fallible for many reasons. Often the person who sees the suspect gets to do so only in a fleeting, short manner. Often it's under great stress when somebody is being robbed or assaulted. We know from social psychologists that cross-racial eyewitness identifications are particularly suspect, that people are much less able to identify those of other races. And so study after study of those who've been exonerated shows that a very high percentage of them were convicted because of false eyewitness identification. We would think in light of this that the Supreme Court would help provide protection for criminal suspects and defendants against inaccurate eyewitness identification. But since 1986, and I picked that date because it's when William Rehnquist became Chief Justice, through today, August 26, 2021, there has only been one Supreme Court case in all of those years about eyewitness identification, and the Supreme Court in that ruled in favor of the police. This is an area where the Supreme Court has simply ignored the problem, even though we know from overwhelming evidence it's something that leads to the conviction of innocent people.
Erwin, it's not just ignoring the problem, right? It's ignoring even the science. No, we talk a lot about what about the science? They've built into the constitutional standard a totality of the circumstances, like how confident the witness is. And now we know that there's really no link. How do you get the Supreme Court to re-examine what they have said is the appropriate standard?
The hope would be that there'll be new cases before them, that the briefs will present that evidence and it will persuade them. On the other hand, in the last case to come to the court, the one I alluded to, the only one since 1986, there were many briefs filed that detailed the kind of evidence that we're talking about. It included what you just said, that there's no relationship between how confident a person is in the identification and how accurate the identification turns out to be. And yet only Justice Sotomayor dissented. And in her dissent, she repeated that evidence, but it didn't persuade even other liberal justices like Ginsburg and Breyer and Kagan to go along with her.
You know, in my class, we sometimes refer to Justice Sotomayor as the rock star. Well, at least I do. And, you know, it seems to me that she tries to bring a bit of the reality, what's actually happening on the streets, to the court. Do you think that's an important voice, and how effective do you think she is?
It's an enormously important voice. When Thurgood Marshall was on the Supreme Court, he could speak about issues of race and policing in a way that nobody else could. He's somebody who had represented Blacks in civil rights cases and criminal cases throughout the South. Justice Sandra O'Connor said she was often so moved by what Justice Marshall said and sometimes changed her mind based on it. Justice Sotomayor is one of the few of the justices who grew up in a disadvantaged background, grew up in the projects in New York. And also she's someone who is very self-conscious, as you say, about her role on the court and the need to speak for people whose voices otherwise aren't heard. There was a Supreme Court case 5 years ago, Utah versus Strieff, which very much expanded the likelihood that police would illegally stop people. Justice Sotomayor wrote a very powerful dissent about the relationship between race and policing. She talked about the talk that parents of children of color have to give. Parents have to tell their teenagers, especially their teenage sons, about how to act relative to the police and how the police behave. No other justice on the current court could have or would have written such a dissent.
By the way, folks, I think you can tell by how Erwin always answers, especially tonight, just off the top of his head, knowing everything about the court, why this is such a rich treasure for us to have. I want to follow up a little bit with confessions. And so we have Miranda, and then we start taking these confessions. Are we getting good confessions? And if not, why not, Erwin?
The premise of Miranda was that police interrogation, when it's in custody, is inherently coercive. Psychological studies show that. Common sense confirms it. If any of us was alone with a group of police officers being questioned, we would find it intimidating. But imagine people who are perhaps less educated than we are, who are less privileged than we are. Imagine people of a different race than the police officers, and how coercive that is. Earl Warren knew all of this from his time as a district attorney and his time as an attorney general. He was very aware of the ways in which police try to trick people into confessing. And so his hope in Miranda versus Arizona was having police deliver the warnings would lessen the coercion. It didn't turn out that way, as you know. Study after study has shown that Miranda had no effect in terms of changing the ability of police to get confessions. Why is that? Well, some of it is often people don't understand the warnings. Some of it is that the warnings aren't enough to lessen the coercive environment. Some of it is that the police deliver the warnings in a way to undermine them. Some of it is that there are times when the police will just violate Miranda, knowing there's other ways they can use the incriminating statements. Some of it is there are things that the police can do to get confessions that they shouldn't be able to do. One, Laurie, that you're so familiar with from your own writing is that the police can lie to a suspect to get a confession. Police can say, we found your DNA, or your other colleague has already confessed and put the blame at you. And the Supreme Court hasn't stopped police from lying about this, and the lower courts have very much allowed it. You put it all together, it's why Miranda didn't have the effect that Earl Warren wanted.
I'm kind of scared to ask this question, Erwin, but where do you see the court headed? And what do you think the impact will be on our civil rights?
We have the most conservative Supreme Court that there's been since the early 1930s. I don't think it's an exaggeration. I think both conservatives and liberals would agree to this. They would just disagree about whether it's good or bad. And it's going to be that way for a long time to come. Amy Coney Barrett was 48 years old when she was sworn in on October 26th. If she remains on the court until she's 87, the age which Justice Ginsburg died, Barrett will be a justice into the year 2059. Neil Gorsuch on that day was 53, Brett Kavanaugh 55, John Roberts 65, Samuel Alito 70, Clarence Thomas 72. I've long thought that the best predictor of a long lifespan is getting confirmed for a seat on the Supreme Court. John Paul Stevens didn't retire until he was 90 years old. So I think we face these being the justices for the next decade or two. And there is nothing from these justices, not any of them, that indicates a recognition of the problems we're talking about or a belief that it's necessary to interpret the Constitution to control the police. So I believe we have to look elsewhere. We need to look to Congress and state legislatures and city councils and police commissions. We need to look to state Supreme Courts interpreting state constitutions. We need to look to the Justice Department to enforce laws that let them go after police departments when there's a pattern and practice of civil rights violation. But it's not going to come from the Supreme Court, not likely in my lifetime.
Erwin, let me follow up on that, because Susan Littman did ask this question. When looking at this, the makeup of the Supreme Court, and it doesn't exactly reflect the rich diversity of America, how do we change things? What more specifically could be the remedies if this is the court we have?
I want to separate how do we improve policing from how do we change the Supreme Court. In terms of improving policing, that's why I was saying we need the legislatures, state courts, the Justice Department to enforce existing laws. In terms of changing the Supreme Court, time, presidential elections. In theory, Congress could expand the size of the Supreme Court. The size of the court isn't set by the Constitution, it's set by federal law. Congress could change that. But the reality is Republicans would filibuster any bill to expand the size of the Supreme Court. It's not going to happen.
There's a commission currently looking at the Supreme Court. What impact do you think it could have on preserving civil rights?
I would be shocked beyond imagination if they proposed anything like expanding the size of the Supreme Court or term limits for Supreme Court justices. I'm hopeful that they might make other proposals that could be helpful, such as for more transparency from the Supreme Court. And I could give many examples of how the court isn't sufficiently transparent and should be. When the Supreme Court denies review in a case, even a death penalty case that means somebody's going to die, we never find out how the justices voted. When the justices take a case, we never find out who wanted to and who didn't want to. Why not? Why is that kept secret?
Erwin, before we get to some of the remedies or suggestions you have, I want to touch on one last sort of broad area, which is Given all the new technology, one of our basic civil rights is our right of privacy. What do you see happening in that era? And can we count on these 9 justices, whatever their backgrounds, to appreciate how it's going to impact privacy?
It's a great question, and I'm very worried. There was a 2018 Supreme Court case, Carpenter versus the United States, that you know so well, that said if the police want to obtain our cellular location information, they need a warrant. Every time we use our cell phones, it connects with cell towers. In fact, even though we're not using it, if it's on, it's connecting with cell towers. And the police can obtain that cellular location information and figure out with a fairly accurate degree of precision where we are at any moment in time. And I was thrilled that the Supreme Court said police need a warrant to access it. But that decision was 5-4 with Justice Ginsburg in the majority. The most conservative justices, Thomas and Gorsuch, said, because there's no invasion of somebody's property rights, no trespass on somebody's property, police don't need a warrant. There are also 2 other dissents. Well, Justice Ginsburg's been replaced by a justice who takes the same approach as Thomas and Gorsuch, saying the Fourth Amendment means what it did in 1791. I don't think Carpenter would come out the same way today. And I worry then that we don't have a court that's willing to apply the Fourth Amendment to the technology of the 21st century.
Do we worry that this court doesn't seem to have a tremendous respect even for stare decisis? And so we can talk about civil rights, but we know that there are cases challenging Roe v. Wade that are on the calendar right now, Erwin. There are cases regarding the Second Amendment on the calendar right now. What do you think is going to happen? Do you think we have a court that will follow stare decisis, chisel away at it, or just not care?
I don't think this is a court that cares much about precedent. As you know, I argued a case in the Supreme Court just a couple of years ago about whether a state could be sued in another state's court. There was a 40-year-old precedent saying they could. The only issue before the Supreme Court was whether to overrule the 40-year-old precedent. And there's no reason to do that. But the court did 5-4 split along ideological lines. I can give you many other examples in just the last few years where the Supreme Court ignored or expressly overruled longstanding precedent. In fact, some of the justices, such as Clarence Thomas and Amy Coney Barrett, have said that precedent shouldn't limit what the Supreme Court does. It should follow the original meaning, even if that leads to overruling precedent. As you said, there's a case that's going to be argued this fall, Dobbs versus Jackson Women's Health, that involves a Mississippi law that prohibits abortions after the 15th week of pregnancy. In Roe versus Wade in 1973, almost 50 years ago, the Supreme Court said states can't prohibit abortions before viability. Viability is generally thought to be the 23rd or 24th week of pregnancy. I think the Supreme Court's going to uphold the Mississippi law and either effectively or explicitly overrule Roe. I can't count 5 fingers, 5 justices who would vote the same way as Roe versus Wade today.
You know, our dear friend Abby Liebman submitted a fabulous question. Good to see you, Abby. In your book, you suggest that maybe some of the changes can come from state leadership. But here in California, we're experiencing this recall election. So how are we going to see progress in the states if you see these type of recall actions going on?
It's a great question. Let me put aside the recall for a moment. After the tragic death of George Floyd, many proposals were introduced into the California legislature to change aspects of policing or to make it easier to sue the police. None of them were adopted last year, even in light of all the public pressure following the death of George Floyd. Now, when you add into that what Abby's referring to, the chaos that might be in state government, makes it even less likely that we will get legislation in this and other areas. Obviously, we'll know relatively soon, September 14th, what happens with regard to the recall.
You know, all of this has sounded almost like a little bit of a downer, Erwin. But I do want to promise people that in this fabulous book, which you will buy from Chevalier, and it makes a lovely holiday gift for Rosh Hashanah too, you have towards the end of the book some really concrete ideas of what could help, from eliminating stop and frisk to written consent for searches, like instead of just asking somebody, telling them that they have the right to say no, to giving counsel during interrogation. Is there traction for any of these suggestions that you're making in this book, or is this the Chemerinsky wish list?
As I mentioned to you, I finished the book last summer and early fall. It was right around this time last year that you read a draft of it for me. And I have to tell you, I was more optimistic in August and September and October 2020 than I am in 2021. After the death of George Floyd, there were protests focusing on policing in every one of the 50 states. A remarkably large number of people participated in these, even in the midst of COVID. I thought it would lead to major legislative reforms. They didn't happen. Now, Laurie, you list many things. All of them are not only possible, all of them are done in some places in the United States. There's not a reform that I articulate that hasn't been adopted in some places. They've been done in some places, they can be done in all places.
What about the big call, the call for abolishing the police? How far are you proposing we go, Erwin?
I am strongly opposed to abolishing the police. I think it's completely unrealistic. I'm not anti-police. Every society needs law enforcement for basic safety and security. Also, the reality is, if we somehow would abolish the police, and we never will, then those with money would just hire private security forces that don't even have to comply with the Constitution. Now, I certainly believe that there are some tasks that we've often asked police to do that we could shift to other agencies. Mental health type functions might better performed by other agencies. But I have no support for those who call for abolishing the police. And also, if you look at opinion polls, even among individuals of color, there's very low support for that because there's the recognition we need to have police. Laurie, as you know, 20 years ago, you and I did a study of the Los Angeles Police Department after the Rampart scandal. And as part of that, I got to interview, 80 to 100 police officers. I was so impressed by the officers who I met. I was impressed by how seriously they took their responsibilities. I was impressed by how many of them said to me that the proudest day of their lives was the day they got their badge. I was impressed by their knowledge of constitutional law. But I also realized that there was a deep problem in the LAPD in terms of its culture, and it wasn't going to reform itself. That's why it's so crucial that we have the Supreme Court or other entities checking the police.
I'm not even going to ask you to comment on our current sheriff, Erwin. But I do want to get your final reaction to this. Towards the end of the book, you write, I wrote this book to show that the Supreme Court deserves a significant share of blame for the problems of policing in the United States. I'm wondering, are you expecting any member of the court to either directly or indirectly respond to those comments?
No.
And so how do you get the messaging to the people who need it the most? I mean, I'm going to send them a copy of your book as a gift, but beyond that, how do we get the message to the court?
I'm not naive. If Sonia Sotomayor can't persuade John Roberts, Erwin Chemerinsky isn't going to be able to persuade John Roberts. I wish that the justices would read my book and be persuaded by it, but I'm neither that naive nor that egotistical. I didn't write the book to persuade the Supreme Court justices. I wrote the book because I wanted to explain to a wide audience something that hasn't gotten enough attention, how the Supreme Court has contributed to the problems of policing and racialized policing. And if people understand, then I think the people can take actions to improve policing in the United States. It's not going to come from the Supreme Court, but it can come through other institutions.
And you also very sweetly write an acknowledgement for your beloved wife, Catherine Fisk. And I want to tell you folks, buy this book just to see the acknowledgement. I'll let you look at it, but all I can say is I keep repeating it to Doug daily as to what can inspire somebody to write a book that makes such a difference. If there are other questions, put them in the chat real fast. Otherwise, I do want to ask, are there more questions that we've got here? Commenting on the ability of police unions to block reforms. Erwin?
The reality is that police unions do block reforms, that police unions are very powerful. I don't know if it's still the case, but I saw a study a number of years ago that the most important endorsement that someone can get running for office in Los Angeles, in California, was that of the police union. And police unions tend to be extremely defensive and very much opposed to progressive change. Of course, that explains why often local governments don't control the police and why we need external controls, like through the Supreme Court. I think that one change that might help relative to police unions, and I write about this in the book, is if local governments were held liable for the constitutional violations of police officers, they would then have much more incentive to control police departments. And when they sat down at the bargaining table with police unions and they said, we can't give you these monetary concessions because we're spending all this money on lawsuits because of police misconduct, I think it could be effective. But we can't ignore the role of police unions.
John Wellborn follows up with that by saying, are there any other public employee unions that you think are standing in the way of reforms?
I just want to focus on police. We could certainly talk, and it's not my expertise, but what other unions and whether they contribute positively or negatively. I can tell a story quickly. I alluded to the report that Laurie and I did on the LAPD. I was asked to do the report by the then head of the Police Protective League, the police union, Ted Hunt. And I was very skeptical and said no when he asked me to do this, because I've always regarded the police union, the Protective League, as the opponent of positive change. But he came back to me several times and I said, look, can I work with anyone I want? And he said, yes. So I asked people like Laurie Levenson and Connie Rice to do this with me. I said, I can say anything I want. You don't get to see it before I release it. I said, that's right. I said, and as soon as I give it to you, I can give it publicly, including to the mayor and city council. I said, that's right. So under those terms, I'm willing to do it. Ted Hunt was an unusual head of the Police Protective League. He was a police officer for his career, but he also had a PhD. At the next election, Ted Hunt was defeated for being head of the Police Protective League. In part, the campaign against him was that he asked Erwin Chemerinsky through a study of the LAPD.
Oh my goodness. Bob Wolf just put in a long question, but Erwin, I'm going to forward it to you after the program because I know we're wrapping up and Bob will get you the answer. But I've always believed that in good manners, one says thank you. And I want to say thank you to Erwin, but thank you to our host, Bert Deixler, and actually give him the last question.
And I want to say thank you. I want to say thank you, Laurie, to you. I want to thank you to Bert, to Chevalier, and all of the people who came here tonight. This has been such a pleasure. Thank you so much.
It is, but you're not done yet, Erwin. The last question does come from our dear friend and host, Bert Deixler. And I think he's just calling on it, which is Justice Breyer repeatedly has claimed that the Supreme Court decision-making is not political. Is he just wrong? Is he deluded? Is he right? What's going on here?
What do we mean by political? In one sense, it's not political. No one lobbies Supreme Court justices in the way you can lobby a legislator or an elected official. You can go to your city council person or your mayor or your state representative or the governor, whoever that shall be, and you can lobby. No one can go to Supreme Court justices and do that. In legislatures, we accept that part of politics is vote trading. To our knowledge, the justices don't trade votes. But if we mean by political, ideological, of course the Supreme Court is ideological. Why did the Republicans block Merrick Garland from even being considered? Why did the Republicans then rush through Amy Coney Barrett? Because they know the ideology was on the court makes all of the difference. Why did Antonin Scalia and Ruth Bader Ginsburg in their lives, when they were both on the court, so often disagree? It's not about one being smarter or knowing the Constitution better. They're both brilliant new constitutional law, but one was conservative and one was liberal. This isn't a new insight. Throughout American history, always the ideology of the justices matters. The Constitution is written in broad language. The meaning it's given, the balancing that's done depends on who's on the court. And I can't believe that Stephen Breyer is saying that it's not ideological. If he is saying it's not ideological, he's just trying to deceive us. That's silly.
Okay. Well, the question for Bob Wolf that you can send him a respond to is about indemnity statutes, but there are many other questions we could have asked. Guess how folks can get those questions answered? Yes, yes, in this wonderful book. So with that said, Bert, thank you for a wonderful evening, and really thank you for having this bookstore, for having Chevaliers, which really is different from the way books are sold across this nation now, because it's sold by presenting the best of the authors, like my friend Erwin, and the most important of topics, like that's addressed in this book. Thank you for a wonderful opportunity.
Thank you both for an amazing evening. It's one of these evenings where I feel better for having sat through the past hour. It was memorable. So thank you both, and thank you everybody for attending.
Good night, everybody.
All right, thanks everyone. If you haven't got your book, bookshop, Laurie, who has just replaced me, which is fantastic, the best spokesperson we could have. If someone you know missed this session and wanted to see it, we post all of our Zoom events on our YouTube page, Chevalier's Books on YouTube. We'll have it posted in the next couple of days. You can check back here. So thank you so much for joining us. We'll see you next time.